Sixth, I reject the idea that the tension that's the subject of this panel today poses a dilemma exclusive to originalism. In fact, to the extent that any judicial philosophy, any sense of jurisprudence posits any standards at all, it would seem that a tension will invariably arise between such standards and respect for precedent. To the extent that these tensions might be more pronounced with regard to originalism, I think this is simply because the standards of originalism, at least in my view, are more bona fide and more genuinely binding standards than those of alternative judicial philosophies. Indeed, to me, this is one of the great and often overlooked virtues of originalism. Not merely that it is committed to respecting the judgments of the lawmaker and to getting the law right by these lights, but that it sets forth a clear standard of decision-making before the case is decided as to how that originalist judge proposes to resolve the dispute. This, I believe, would be a virtue even if the standard was more deficient than conforming with the intentions of the lawmaker. The originalist judge promises that he will resolve the case before the case is presented to him by looking to all the evidence that is relevant in discerning the meaning of language in dispute and nothing more. When, on the other hand, a judge is committed merely to a judicial philosophy of resolving disputes, say, fairly or justly or in conformity with natural justice or pursuant to the demands of contemporary society, it is conceitedly more difficult to discern clear tensions between the product of those malleable non-standards and precedent. Nonetheless, to the extent that any judicial philosophy contains meaningful standards for decision-making, and such standards are at the root of the rule of law, I think, there will arise inevitable frictions between that philosophy and precedent. Seventh, which leads me to my own reconciliation of originalism and precedent. Just as I have submitted myself to standards in deciding what a proper construction of the law requires, I have also submitted myself to standards in determining when that construction must be tempered by the requirements of precedent. While such standards aren't mechanical and involve exercises of judgment, so does exercise of the judicial power generally. Whenever it can be done, I favor minimizing judicial discretion, and minimizing judicial discretion in reconciling originalism and precedent is to have standards. Once again, standards clearly known before the case is decided for determining in which of these parallel universes of originalism and stare decisis the court will place a case. That is, it is to establish standards for when to depart from the standards of originalism. And in Michigan, in the case of Robinson versus City of Detroit, a very much cited 4-3 decision, my court stated that while stare decisis is the default position, it is, quote, not to be applied mechanically to forever prevent the court from overruling earlier erroneous decisions. Quoting Justice Powell and Mitchell versus Grant, it is thus not only our prerogative but also our duty to re-examine a precedent where its reasoning or understanding of the Constitution is fairly called into question. We then set forth several factors that are to be considered in determining whether originalist or precedential principles will apply. Threshold among these factors, of course, is whether the precedent is viewed as incorrect. If it is not, then there is no conflict between originalism and precedent. If it is viewed as incorrect, then we assess other interests, such as reliance. In one case, for example, reliance interests were viewed as determinative, where several generations of the plaintiff class had insured themselves against a particular risk on the basis of earlier court decisions, while similar generations of the defendant class had not. We chose to abide by that precedent rather than placing suddenly an unforeseen and uninsured against burden upon the defendant class. We will also look to see whether the precedent has, quote, become so embedded, so accepted, so fundamental to everyone's legal expectations that to change it would produce not just readjustments, but practical, real-world dislocations. And perhaps most importantly, we'll look to the specific language of the law itself and to the precedential court's analysis of that language to assess whether the predictability of the law is furthered more by retention of that precedent or by a recognition that citizens scouring that law in order to ascertain their legal duties and responsibilities also possess a legitimate reliance interest. We said it is to the words of the law that a citizen first looks for guidance in directing his actions. This is the essence of the rule of law, to know in advance what the rules of society are. If the words are clear, the citizen should be able to expect that they will be carried out by all in society, including the courts. Should a court confound those legitimate expectations by seriously misreading or misconstruing a statute, it is that court itself that has disrupted the reliance interest. Finally, I am content that my court, for a period of more than a decade, in more than 25,000 cases, has moved unwaveringly in the direction of attempting to conform our case law with the language of the law as we saw it. There are fits and starts, pauses, and junctures at which in our judgment the law needed to move forward more gradually, or where deference to precedent was warranted by our standards. But in our adoption of the Hippocratic Oath, we sought never to do harm to the law, never to widen the gap between the positive law and the decisions of the court, never to call into question our commitment to this objective as our limit. And I believe this was no small contribution in the current legal culture. We squarely rejected the premise of the ratchet theory by which so many previous generations of judges, particularly conservative judges, have been persuaded that it is only the non-interpretivist judge who gets to make new precedents, and that the role of the interpretivist judge is to reconcile himself to those and to institutionalize those precedents. Once again, I think that's no small contribution, and that summarizes my attitudes toward the subject matter of this panel today. Thank you.